Hello, we will be reviewing the authorized buy-sell agreement of the Greater Kalamazoo Association of Realtors, also known as GCAR. At the very top of this agreement, there's a date and also an AM and PM indication of what time that the agent is filling this document out. There's also a form number that's on this at the upper right-hand corner, as well as an MLS number. The form number can be an assignment of letters or numbers or anything that the buyer chooses. We typically recommend that the form number begin with the numbers of the address being purchased and then the letters of B, S, and A, which can stand for buy-sell agreement. The MLS number can be found on your local MLS listing and can be drafted in that empty spot. With this buy-sell agreement, also known as a purchase agreement, GCAR has decided to use the term buy-sell agreement. So if you hear someone say buy-sell agreement or purchase agreement, they can be interchangeable. The first beginning sentence on these buy-sell agreements states that the undersigned buyer and seller, the parties, each acknowledge that they have read and signed the real estate agency disclosure. The next point within this buy-sell agreement is the agency relationship at the time of execution of this agreement are as follows. At the very top of the buy-sell agreement, there are spots for the listing broker and who the listing broker represents, either the seller only, seller and buyer as a disclosed dual agent, or neither, a transaction coordinator. On the same side of this buy-sell, there's a spot for the listing salesperson to explain who they represent, either the seller only, the seller and buyer as a disclosed dual agent, or neither, a transaction coordinator. On the opposite side, it does allow for the buyer's agent and buyer's broker to indicate who they represent. Under the selling salesperson within the buy-sell agreement, there's a location that the selling salesperson can indicate that they represent a buyer only. If a buyer's agent checks the buyer only spot and indicates an addendum number, there is an additional topic that is not being addressed here, which will be addressed under another section, known as the addendum to the authorized buy-sell agreement. And that addendum to the authorized buy-sell agreement will indicate how the buyer is compensated. Paragraph 1, prior offers. This offer terminates any prior offers or counteroffers between the parties for the property. This is a very straightforward concept and basically states that if there are any current offers or other offers that have been previously negotiated, that this current offer will take precedence and be the final offer that both parties can review and agree to. Paragraph 2, property description. Buyer agrees to buy from the seller the property whose address is blank. It will indicate the property address, city, state, and zip code. The property is located in the city, village, and township of blank, whatever township, city, or village that the home is located within. You will also have to indicate the county name and the legal description of the property. You will also need to indicate the tax ID number of the property. The legal description and tax ID number can be found under the BSA software Google search. Within that website, you can locate your county and then enter the address, and you will be able to find the legal description and tax ID, also known as the parcel number for the property. Within paragraph 2, it states the property shall include all buildings, improvements, appurtenances, fixtures, and if now in or on the property, the following. There is a massive list of items here within paragraph 2 that we encourage you to read. One thing that I would like to clarify is appurtenances. This is a term, a legal term, that means any property or land that gets attached to the property or land being sold. One of the issues that we see often in paragraph 2, that was a recent addition from GCAR, are hot tubs. If a hot tub is on the premise, it would be wise for any agent to ensure and verify whether the hot tub is going to be part of the purchase agreement, in this case a buy-sell agreement, or if it's going to be part of personal property. If it's part of personal property, a chattel agreement would need to be initiated between buyer and seller, and both parties would need to agree with an understanding of who will be keeping that hot tub. Within paragraph 2, there's also a place that will state, but shall exclude rented items and blank. If there are rented items on the property, it's important that the buyer and seller both agree on what will happen to that rented property. If there are any excluded items that are not going to be part of this buy-sell, it's also important that a buyer and seller also agree within the purchase agreement or on another addendum on how to agree on who will keep or who will sell certain items within a purchase agreement. Paragraph 3, sales price. This is the point where you would end up listing the actual number that your buyer is wanting to ask to purchase the property. There's a place where you will actually place the number for the sales price, and then you will also handwrite out the language. For example, if you were to put in $100,000, you would also spell out $100,000. Paragraph 4, closing. Sale shall be closed on a day and time mutually agreeable to the parties, but not earlier than blank and not later than blank. Buyer shall pay any closing fee charged by a title company, except seller shall pay said closing fee and wood-destroying insect inspection fee or fees if required by a VA loan. Seller shall pay real estate transfer taxes at a time the deed is delivered. With regards to closing, it's important to understand that if you have a time frame for closing, for example, if you decide that you are not going to close earlier than January 1st of a certain year and no later than January 7th, if both parties don't mutually agree on when to close during that time frame, the agent should be aware that both parties are going to agree at the latest date indicated on this. So in my example, it would be January 7th that both parties would automatically default to an agreement for closing. Paragraph 5, possession. Buyer shall be entitled to possession of the property as follows. And it says check one box. Either possession can be at the completion of closing, or seller shall pay buyer at closing a non-refundable delayed possession fee of blank dollars, and shall have the right to possession of the property until 11:59 p.m. on a certain date, and that date would be the day after the day of closing. Seller should not be entitled to possession after the time agreed upon above, unless otherwise provided in writing and signed by the parties. Seller shall provide possession of the property free from the rights of any other person or entity, including but not limited to tenants. At the time of transfer of possession, the property, seller shall have removed all personal property, unless otherwise stated in this or an additional written agreement, made arrangements for final payment on all utilities, and shall deliver all keys to selling broker or buyer. The property shall be free and clear of trash and debris. Buildings and improvements shall be left in broom-clean condition. Seller shall maintain the property in its present condition until time of possession in this transaction. Normal and reasonable wear accepted. Seller shall pay for utilities and for any repairs due to damage caused by the seller to the property after closing and before the transfer of possession. The seller is responsible for obtaining any insurance seller deems necessary, covering seller to the time of transfer of possession. If seller fails to give possession to the buyer as provided, seller shall pay buyer blank for each day that the seller retains the property. Buyer's agent should be aware that if the seller refuses to give up the property even after closing, that this is where a buyer's agent would put in a penalty that would be assessed to the seller for staying on the premises even after closing. Paragraph 6, attachments. Attachments in the buy-sell agreement for G-Car is where all documents that are going to be attached to the buy-sell would be indicated. An agent can either check no or yes attachments and or addendum numbers. So for example, certain attachments that people may assign to this would be a seller's disclosure. Could be a lead-based paint disclosure. It may be the addendum only or the addendum to the authorized buy-sell agreement on how a buyer is compensated from the seller. We may also attach certain exhibits. For example, many times when we are filling out the legal description is too long for us to actually place within the buy-sell agreement. And therefore, we end up getting a Word document and we label it Exhibit A, legal description. And below that is where we would actually indicate the legal description of the property. Again, any exhibits would also be placed under paragraph 6. Paragraph 7, disclaimer. Buyer understands and agrees that the real estate brokers and salespersons do not warrant the following. 1. The property's boundaries, the size of the land, the size of the buildings and improvements. 2. The condition of the property. 3. That appropriate permits were obtained for repairs or other work performed on buildings or improvements made by the seller. It is further understood that no representations or promises have been made to the buyer by the real estate broker or salespersons or by the seller other than those contained in this agreement or as otherwise made or given by seller to buyer in their written disclosure statements. The parties understand that brokers and salespersons are not environmental experts unless expressly contained in a written instrument signed by the brokers. Brokers and salespersons have no knowledge of and make no representations regarding A, the environmental condition of the property, B, the existence of underground storage tanks at the property, now or in the past, C, whether the property has been, or may be listed as a site of environmental contamination, or D, whether any such sites are located in the proximity of the property. If buyer or seller requests the broker or salespersons to recommend inspectors, repairmen, and other professionals, the parties agree that the brokers and salespersons shall not be liable for errors or omissions made by said inspectors, repairmen, or other professionals. Paragraph 8. Buyer investigations. A. Buyer acknowledgement. Buyer acknowledges that buyer has been advised to carefully evaluate the property to determine its conditions and suitability for buyer's intended use. Buyer is aware that inspectors and inspection services are available to aid buyer in these evaluations. Items buyer should evaluate include, but are not limited to, the following: structural integrity, condition of mechanical systems, infestation by termites or other wood-destroying insects, environmental concerns such as underground storage tanks or abandoned uncapped wells, health or safety issues, including radon and mold, zoning, assessed valuation, including the principal residence exemption status and any possible changes to that status, the size of the land, the size of the buildings and improvements, the availability of utilities, including the cost to extend or hook up, soil, erosion or settling, the existence of wetlands, the availability of homeowners insurance or flood insurance at a cost acceptable to buyer. Section B. Buyer investigation period. Buyer shall have 10 days from the last dated acceptance of this agreement, also known as an investigation period, to investigate the property. During the investigation period, buyer and buyer's investigators shall have reasonable access to the property to conduct investigations as buyer deems necessary. Buyer agrees to defend, indemnify, and hold seller harmless from any physical damage to persons or property resulting from such investigations. To the extent the property is damaged due to any of the buyer's investigations, buyer agrees to restore the property to its original condition. Buyer is solely responsible for ordering and paying for any inspections and evaluations, except if buyer has elected to use VA financing, seller shall pay for the wood-destroying insect inspection at closing. Section C. Seller responsibility concerning utilities. Seller shall have the following utilities, if attached, turned on for buyer's investigations: appraisals and final inspection, electric, natural gas, propane, heating oil, sewer, and water. Seller shall be solely responsible for dewinterizing, rewinterizing, and any and all costs and procedures associated with these subparagraphs. Section D. Results of investigation. If any investigation reveals a condition unacceptable to the buyer, then prior to the expiration of the investigation period, which is that 10-day period, buyer may pursue one of the following resolutions. 1. Buyer may deliver to seller or listing broker a written request for corrective action, and that can be placed on either the G-CAR Investigations Addendum or a similar notice, along with any documentation or reports with written estimates. Once the buyer submits that written request for correction, the seller shall have 5 days from the receipt of that addendum or similar notice to respond to the buyer in writing as to whether the seller will agree to pay for and or perform said corrective actions. Here's a very important point. If the seller rejects any part of the buyer's request in writing, buyer shall have 3 days from the receipt of seller's written rejection to terminate this agreement in writing. If the seller does not respond in writing after a written notice from the buyer has been presented, buyer shall have 3 days from the expiration of the seller's allowed 5-day period to terminate this agreement in writing. If the buyer fails to so terminate this agreement, buyer shall be deemed to have accepted the condition of the property in its as-is condition, or buyer may terminate this agreement by providing written notice of the termination to seller or listing broker, identifying the unacceptable condition that they have found during their inspection period. If requested by seller, buyer shall provide seller with a copy of any inspection report or documentation of unacceptable condition. Buyer's agent should be aware that they will have a 10-day period from the last dated acceptance of the agreement. Again, this 10-day period is known as an investigation period. Once the inspections are completed and the buyer finds a problem that they want the seller to address or correct or rectify, a notice will be provided from the buyer to the seller within that 10-day investigation period. Once the seller receives that notice or written request for corrective action, the seller only has a 5-day window to either accept your written request for corrective action, deny it, or blatantly just ignore you. After that 5-day window passes, if you do not hear anything from a seller's agent, you will then have a 3-day period to either write up a written termination on behalf of your client or accept the home in its as-is condition and move forward. Section E, waiver of contingencies. Buyer agrees that the contingencies in this paragraph shall be deemed to have been waived if 1. Buyer fails to deliver written notice of buyer's proposed resolution to the seller or listing broker within the investigation period, or 2. Buyer fails to terminate this agreement in writing as provided above. If these contingencies are waived, or if the buyer elects to close this transaction, buyer shall be deemed to have accepted the property in its as-is condition as of the date of closing. Therefore, buyer's agents should be very cautious and mindful of the timeline that they have of this 10-day period to perform their due diligence and also to provide any written notice of corrective action. If a buyer's agent fails to provide a written notice of corrective action after this 10-day period, it will not be an allowed addendum, and therefore it will be as if the buyer has accepted the home as is. Paragraph 9, locations of boundaries and improvements. Buyers may, at buyer's expense, obtain a survey or mortgage report. If the survey or mortgage report 1 reveals material differences in the property's boundaries or land area from that which was represented by the seller, or 2 reveals encroachments, setback violations, or matters which would interfere with the buyer's intended use of the property, also known as survey defects, buyer shall furnish seller with a copy of the survey or mortgage report along with a written request that the seller correct these survey defects. These must be received by seller no later than 15 days after delivery of the title commitment. Seller shall respond in writing to buyer within 5 days as to whether or not the seller will correct the survey defects. If the seller does not agree to do so or fails to respond to your written request as a buyer's agent, buyer shall have 3 days from the receipt of the seller's written refusal, if any, or from the expiration of the seller's allowed time, whichever first occurs, to terminate this agreement in writing. Buyer agrees that this contingency shall be deemed waived if 1. Buyer fails to provide seller with a survey or mortgage report, or 2. Buyer fails to terminate this agreement in writing as provided above. If this contingency is waived and buyer elects to close this transaction, buyer shall be deemed to have accepted the location of the property boundaries and improvement as is. Paragraph 10, well, water, septic system evaluations. If the property is serviced by a water well, seller agrees to order within 5 days of the last dated acceptance of this agreement and promptly provide to buyer and or selling broker at seller's expense an evaluation report from the county health department or the private well evaluation company listed in paragraph 11, covering the well and tests for nitrates and bacteria. Any water evaluation beyond tests for nitrates and bacteria shall be buyer's responsibility and at buyer's expense. If the property is serviced by a septic system, seller agrees to order within 5 days of the last dated acceptance of this agreement and promptly provide to buyer and or selling broker at seller's expense an evaluation report covering the condition of the septic system by the local county health department or the private septic evaluation company named in paragraph 11. Within this statement, it does state here that the seller agrees to order within 5 days an inspection report on the septic system. Now, it doesn't mean it has to be completed. It just means that the seller has to pick up the phone and arrange to have the septic system inspected. Now, we don't know when that company is going to come out, so it could be, a week before closing. But hopefully that what you're seeing is that that phone call is made immediately and that arrangements to have both the well and septic are going to be addressed hopefully within the first 7 to 14 days after signing a contract. Seller further agrees to have the septic tank pumped if required by the local county health department. If the evaluation report or reports in any of the above circumstances discloses a condition which buyer reasonably deems unacceptable. Buyer shall notify seller or listing broker of such condition and requested corrective action. This has to be in writing, and the requested corrective action must be provided within 5 days of the date buyer has received the applicable report. What that means is that the seller will provide the buyer's agent with this well and septic report, and then you will have 5 days to respond in writing if there is a condition that is unacceptable to your buyer. And within that, normally we would ask for some type of corrective action if that's what the buyer is wanting. Once you submit a request for corrective action within your 5-day period after you get the reports from the seller on the well and septic, if the seller does not agree or fails to respond within 15 days of the buyer's requested corrective action, the buyer shall have the right to terminate the agreement by providing written notice to the seller. So the seller will provide the buyer with a report for the well and septic. The buyer will have 5 days to review those reports, and if there is something that is deemed unacceptable, the buyer within that 5-day must provide written notice to the seller. The seller will have 15 days to review that request and either accept and make those corrections or not even respond. It does not give the right to the seller to terminate. If the seller does nothing and does not respond, you'll have to wait that 15-day period. Once that 15-day period elapses, then you will have 3 days to actually write up a termination notice to the seller. So it's important that we understand these timelines and that we read the paragraphs. Furthermore, buyer agrees that the contingency provided by this paragraph shall be deemed to have been waived if 1. Buyer fails to provide written notice of a condition deemed unacceptable within 5 days after buyer has received the report from the seller, and 2. Buyer fails to terminate this agreement in writing as provided above. If these contingencies are waived, or if buyer elects to close this transaction, buyer shall be deemed to have accepted the property in its as-is condition as of the date of closing. Paragraph 11. Private well and/or septic evaluation companies. The parties agree that the following shall be used to evaluate the well, water, septic system for paragraph 10. For evaluation of the well and water, blank. For evaluation of the septic system, blank. A blank line indicates the agreement of the parties to use the local health department. In paragraph 11, the buyers have the opportunity to state which company they want to use for a well and septic inspection. If these are left blank, it's going to be addressed that the buyer is asking to have the local county health department perform such inspections. Paragraph 12, source of funds. This agreement, either A, is not contingent on the sale or exchange of any real property or personal property by buyer. Buyer represents that the funds necessary to complete this agreement on the terms specified are currently available to buyer in cash or an equally liquid equivalent. B is contingent on 1. The close of the pending sale of buyer's property located at blank. A copy of the agreement to sell or exchange buyer's property is being delivered to seller or listing broker along with this offer. Buyer shall notify seller or listing broker in writing within 48 hours of any changes in the terms or progress of said agreements that will delay or materially affect the consummation of this agreement. In such an event, seller may terminate this agreement by written notice to buyer or selling broker within 48 hours of receipt of said notice from buyer. Failure of buyer to notify seller of such changes or a default by buyer in said agreement shall be considered a default in this agreement. It's important to understand under this section that if a buyer is going to submit a buy-sell agreement with the source of funds of is contingent on the close of the pending sale of buyer's property, it's important that the buyer's primary residence actually already has a pending offer solidified to it, because you will need to provide a copy of that other buy-sell agreement along with this buy-sell agreement to the seller for them to make a decision on whether to accept the buy-sell agreement. Other, this is just left blank in case there are other options for a buyer that they choose to want to indicate that the offer is contingent upon. Paragraph 13, method of payment. All monies must be paid in U.S. funds by wire transfer, certified check, cashier's check, or money order. The sale will be completed upon seller's delivery of a warranty deed, conveyed marketable title by the following method. A, cash, where the buyer will pay the sales price by cash, certified check, cashier's check, or money order. B, a new mortgage. This agreement is contingent upon buyer's ability to obtain blank type of mortgage loan in the amount of blank or blank percent of the sales price. This is where a buyer's agent would spell out what type of mortgage loan are they obtaining. Is it a conventional, FHA, RD, VA? And it will also specify the percent of the sales price. If the person is putting down 10%, you would indicate 90% of the sales price is being financed. You will also indicate that the buyer shall apply for the loan from blank, the name of the financial institution or lender, within blank days of the last dated acceptance of this agreement. There's a spot here for how many days that the buyer has in order to actually contact their lender and start the loan approval process. A lot of agents may put 3 days, some will put 5 days, some may put 7 days. But the sooner your client ends up contacting the lender and getting the process started, the faster this entire process can get to the very end and for you to get to a closing. Furthermore, within Section 13, it states, loan applications shall include the payment of any appraisal fee, application fee, and all other costs customarily charged by lender for loan approval. Buyer acknowledges that failure to complete the loan application as agreed shall constitute a default by buyer. Buyer shall take no action that would impair buyer's credit or ability to obtain the loan and shall accept such loan if offered. Buyer may waive this mortgage loan contingency by written notice to seller or listing broker and pay cash as provided in subparagraph A above. To summarize this, it means that as a buyer's agent, you need to explain to your buyer that as they move forward in this process, that they're not going to tank their credit. They're not going to go out and buy a brand new car that may disrupt their income to debt ratios and therefore all of a sudden not become eligible for a new mortgage. By doing that, they could be in breach of contract and could potentially lose their earnest money or good faith deposit. In addition, it states that seller may terminate this agreement by written notice to buyer or selling broker if buyer fails to provide seller or listing broker with evidence of loan approval by 5 p.m. on blank date, also known as a loan approval date. The loan approval date on here is the actual date that your buyer is going to actually have a lender give them a clear to close or loan approval. Typically, what we recommend is that we contact the lender and ask them, how long will it take for them to give you a clear to close? Is that going to be 28 days, 30 days, 35 days? And then indicate that date on your form here. The loan approval deadline date is another future covenant time frame that needs to be met. Failure to meet that can cause your client to be in jeopardy of having their contract terminated. If the buyer is unable to obtain written verification of lender approval, buyer may provide oral verification from lender to seller or listing broker. If said loan approval is acceptable to seller, no response shall be necessary. If seller reasonably determines that the evidence of loan approval is inadequate or unacceptable, and if seller therefore wishes to terminate, seller must deliver written notice of termination of this agreement by 5 p.m. on the third day after the loan approval deadline date. So again, if you do not have loan approval by a certain date that's indicated in your buy-sell, after that date comes and goes, the seller can have 3 days to either call up the lender to verify whether your buyer is going to get loan approval. If they don't feel that the lender can provide them with a justified loan approval after 3 days of the loan approval deadline, the seller can therefore terminate the buy-sell agreement. If seller so terminates, buyer may waive this mortgage contingency and void a termination by delivering written notice of such waiver to seller or listing broker by 5 p.m. on the third day after seller's delivery of termination. If buyer waives this mortgage contingency and subsequently fails to close due to buyer's failure to secure financing, buyer shall be considered in default in this agreement. Again, it will be important for your buyer to ensure that they get that loan approval by the deadline or risk potentially having this deal be terminated. Buyer hereby instructs lender to release to selling broker and seller or listing broker information concerning completion of the loan application and status of loan approval. Again, this paragraph should be taught to your client that the buyer is instructing the lender to release any information to the listing agent or listing broker so that they can verify whether your client will be obtaining loan approval. Section C, Land Contract. See attach a G-CAR Land Contract Addendum. Again, this is another form of method of payment. If someone were to choose a land contract, this will be addressed under another topic known as G-CAR Land Contract Addendums. Section 14, Seller's Disclosure Statements. The seller's disclosure statement says that buyer either has or has not received a completed and signed copy of the seller's disclosure statement. It also gives a spot in here for the number of the seller's disclosure, form number, and the date or revised date of that seller's disclosure. Seller hereby certifies that to the best of seller's knowledge, the information contained in such seller's disclosure statement is current as of the date of this agreement. Further, seller agrees to inform buyer in writing of any changes in the condition of the property relating to the information contained in such disclosure statements. That's an important point in the buy-sell agreement for G-CAR. There are other purchase agreements where you don't need to update the seller's disclosure, but in this sense, we are spelling out that if the seller has a change in the status or condition of the property, that they must update their seller's disclosure form. Paragraph 15, lead-based paint disclosure statements. Buyer has or has not received both an EPA pamphlet Protect Your Family from Lead in Your Home and a completed and signed copy of the seller's lead-based paint disclosure statement number, indicated blank on the form. If the property was constructed prior to January 1st, 1978, buyer will not be obligated to the terms of this agreement unless the above documents are received by buyer. If the above documents are received after the last dated acceptance of the agreement, buyer shall have the right to terminate this agreement within 72 hours after the buyer's receipt of the above documents if the seller's lead-based paint disclosure statement indicates any condition unacceptable to the buyer. If buyer fails to terminate this agreement within said 72 hours, buyer's right to terminate under this provision shall be considered waived. Please understand that if a buyer does not actually get a copy of the lead-based paint disclosure form, once they get a copy of that form from the listing agent or seller, they will have the right to review that form and within 72 hours terminate the purchase agreement if they so desire. So it's important that as a buyer's agent, you check whether they have or have not received a copy of that lead-based paint disclosure form. Now keep in mind, any property that was built after January 1st, 1978 is exempt from actually needing a lead-based paint disclosure form. Paragraph 16, title evidence. Seller agrees to convey marketable title to the property subject to conditions, limitations, building and use restrictions, and easements of record exceptions. As evidence of marketable title, seller shall furnish buyer at seller's expense an expandable coverage Alta homeowner's policy of title insurance, if available in the amount of the sales price. Seller shall order the commitment for such policy along with copies of the exceptions, and shall deliver to buyer or selling broker within 10 days after the last dated acceptance of this agreement. What that means is once a buy-sell agreement is executed, the listing agent will actually have 10 days to provide you with a copy of their title work for you to review and to ensure that everything within the title and any exceptions are acceptable to your client. If a survey or mortgage report is required by the commitment, it shall be completed at buyer's expense in accordance with paragraph 9, location of boundaries and improvements. If an expanded policy is not available, or if buyer declines any required survey or mortgage report cost, seller agrees to provide and buyer agrees to accept a standard coverage Alta owner's policy of title insurance, including all standard exceptions. If the commitment discloses any title defects or anything in the exceptions which would interfere with the buyer's intended use of the property, buyer must notify seller or listing broker in writing of buyer's objections within 5 days of seller's delivery of the commitment and exceptions. So again, once you get this title work, you need to read it. You need to ensure that your buyer does not have any objections to anything within the title work or any of the exceptions within that information provided. If prior to closing, Buyer shall become aware of new title defects. Buyer must notify seller or listing broker in writing within 5 days of buyer becoming aware of such defects. If seller receives any such notification, seller shall have either 30 days from buyer's delivery of written objection or until the latest closing date set forth in paragraph 4 of this agreement, whichever first occurs, to resolve buyer's objections. If seller is unable to cure the title defects or unable or unwilling to resolve buyer's objections to exceptions within this time period, buyer may terminate this agreement in writing and receive a full refund of the earnest money or proceed to closing, accepting the status of the title as is. Paragraph 17, Prorations. Items normally prorated in real estate transactions, including association fees, rental income, taxes, are discussed below. Interest on any existing land contract, mortgage, or lien assumed by buyer shall be adjusted to the date of closing in accordance with the calendar year. All rental security deposits shall be paid to buyer at closing. Paragraph 18, Real estate taxes. Current real estate taxes shall be prorated to the date of closing and shall be deemed to cover the calendar year in which they became due and payable. Taxes shall be deemed due and payable as follows. Summer taxes, July 1st or August 1st. Winter taxes, December 1st. If the actual tax bill or bills for the year have not yet been determined by the municipality at the time of closing, taxes shall be estimated by multiplying the current taxable value by the most recently available tax rate. If the property's principal residence exemption, also known as PRE, status for the calendar year in which the closing occurs will change as a result of the closing, the tax rate associated with the new PRE status shall be used. If the current PRE percentage claimed by seller is greater than 0, seller represents that such claim by seller is accurate and lawful. Such representation shall survive the closing. Seller shall defend, indemnify, and hold harmless buyer from any loss, claim, or damage resulting from any inaccuracy in such representations. Such loss, claim, or damage shall include, but shall not be limited to, any loss, claim, or damage resulting subsequently to buyer from the tax proration calculation made at the time of closing or from the change in PRE status by the municipality for any prior years. Seller shall also be responsible for reasonable and actual attorney fees incurred by buyer in enforcing the provisions of this paragraph, regardless of whether suit is actually filed. The representations and obligations under this paragraph may only be terminated by a separate written document signed by the parties specifically referring to this paragraph by number. So in general, buyer's agent should be aware that with real estate taxes, that the real estate taxes will be prorated to the date of closing, and they will cover the calendar year. Paragraph 19, Special Assessments. Special assessments levied on the property shall be handled as followed. A. Existing special assessments, whether there is a lien or not, which can be paid in full and permanently discharged, shall be paid by the seller, and at closing. Section B. Existing special assessments, which have ongoing installments and cannot be paid in full and permanently discharged, shall be prorated as referenced in the paragraph entitled Prorations. This type of assessment is generally for services or maintenance, including but not limited to street lighting, lake weed control, emergency services, etc. C. Special assessments, which are levied on the property after the last dated signature of this agreement, shall be the responsibility of buyer. Again, this section is actually just spelling out that if there's an existing special assessment and it can be discharged, a seller will pay for that at closing, or if there's a special assessment that needs to be prorated, then both parties will be responsible, or after closing, any special assessment that comes to light shall be the responsibility of the buyer. This is important to understand because with some other purchase agreements, the special assessment may fall on the buyer to pay for everything prior to closing. In G-Car, it's not that way, but with other purchase agreements, you may find that special assessments are quite different. Paragraph 20, Water, Sewer Charges. Seller shall be responsible for water and sewer charges until date of possession. The cost of water and sewer hookups after closing shall be paid by buyer. If the property is not presently served by these utilities, buyer is advised to consult with the local units of government for information regarding when and if such hookup is or may be required, the feasibility and cost of such hookup, and whether any assessments will be imposed at that time. Often, as a buyer's agent, when you have a seller who has a septic system and they're in the process of potentially hooking up to city water or city sewer, it needs to be explained on who's going to pay for certain charges. So that may be a discussion that we recommend buyer's agents have with a seller prior to writing up a purchase agreement, or during the time of once you end up getting the inspection reports back on well and septic. If you were to learn that you now need to hook up to city water, such expenses should be addressed within an addendum for both buyer and seller to agree upon. Paragraph 21, liquid fuel. Seller agrees that the existing supply of liquid heating and cooking fuel shall be depleted only in the course of normal usage. Buyer shall be entitled to all such fuel owned by seller and located or stored upon the property at the time of possession. Buyer acknowledges buyer has been advised to determine whether any existing supply of liquid fuel is owned by the seller or the supplier. Buyer's agents normally will end up seeing this when you have a home that is heated with propane and you have the large propane tanks on the premise. Again, existing supply of the liquid fuel shall only be depleted during the normal course of usage, and that liquid fuel that remains in that tank will become property of the buyer. When in doubt, we always encourage buyer's agents to write this into an addendum or their purchase agreement that any liquid fuel that remains within these tanks will become the owner of the buyer. Paragraph 22, seller's representations. The following representations shall survive the closing, and except as otherwise disclosed in writing, seller represents to the best of seller's knowledge and belief that A, there is no existing violations of any laws, statutes, ordinances, regulations, orders, or requirements of any governmental authority affecting the property. B, there is no pending or threatened litigation, administrative action, or claim relating to the property. C, seller has not been notified of any assessments to be placed on the property. D, the seller is the owner of title to the property in the condition required for performance hereunder. Paragraph 22 also addresses when you have a property that is rented to tenants. It states as follows: if the property is rented to tenants. E, as referenced in paragraph 5, seller shall notify buyer or selling broker in writing of the possession rights of any person or entity, including but not limited to tenants. Seller shall provide copies of all leases and security deposit information to buyer or selling broker within 3 days of the last dated acceptance of this agreement. What that will mean is if you are a buyer's agent and you are helping investors, or you buy a home that has a tenant in it, the seller must provide you with copies of all leases and security deposit information within 3 days of executing the buy-sell agreement. This agreement, or buy-sell agreement, is contingent upon buyer's written acceptance of such possession rights, leases, and security deposit information within 5 days of receipt of such notices and copies. If seller does not provide such notice and copies within such 3 days, seller warrants that no other person or entity has possession rights. If buyer receives such notice and copies and neither accepts nor rejects such items within the 5 days, buyer shall be deemed to have accepted them, and this contingency shall be deemed satisfied. So it's important as a buyer's agent to understand that you do have an opportunity to review all the leases associated and security deposits associated with that property. If you find that such leases are not acceptable, you do have an option to terminate the purchase agreement. But again, you have to ensure that you're following the time frame of that. If you fail to respond within the initial time frame allotted to you, you will then be accepting the leases and tenants as is. F, none of the tenants occupying the property shall be entitled to any concessions, rebates, allowances, or free rent for any period after the closing date. G, after the date hereof, the seller will not enter into any agreement pertaining to the property or any modification of or release from an existing lease or rental agreement without the prior written consent of buyer. This helps to ensure that as a buyer or investor, that the seller is not going to go in and all of a sudden cancel leases or make modifications to the premises. They will need to ensure that they have your permission to make such changes. Paragraph 23. Final inspection. Buyer shall have the right to inspect the property within 72 hours prior to closing to make sure that the real estate and personal property are in place and in a condition that is not substantially different from the condition at the time of buyer's offer per this agreement, or as improved by any agreed-upon corrective action. If substantial differences have occurred, then buyer shall immediately notify seller and/or listing broker in writing of said differences and buyer's requested corrective action. The parties shall be deemed to have settled such differences as of close of sale. Broker and or salesperson have no responsibility for the condition of the property. As a buyer's agent, it's important to ensure that within your final walkthrough that you, one, make sure that any corrective actions that were previously negotiated have been performed. And number two, ensure that the property is in a condition that is acceptable to your client. You should also be aware as a buyer's agent that once you close, you won't have any ramification to go back onto the seller after closing. At least if you walk into a property and you find that there's debris and personal property that was supposed to be removed, you can have an option to delay closing and that way ensure that the property is in a condition that was agreed upon in the purchase agreement or any addendum. Paragraph 24, disclosure. Buyer acknowledges buyer has been advised that seller and seller's agent may not consider the existence of or terms of buyer's offer to be confidential. The parties further acknowledge that the sales price and terms will be disclosed to GCAR, the MLS, SWMRIC, who may use it in the ordinary course of business. So this is important to understand that buyer has been advised that seller and seller's agent may not consider the existence of the terms confidential, meaning that the seller has the right and the listing broker to post the closing information on what the home finally sold for, and that information will not be confidential. So buyers just need to be aware that when they buy a home, that this information will be available to the general public if they wanted to find this out. Paragraph 25, Unplatted Lands. Seller represents that the property is not a new land division under the Land Division Act, and seller owns no other contiguous, unplatted land unless otherwise disclosed in writing. Seller is transferring to buyer all available divisions, if any, under Section 108 of the Land Division Act, but makes no representations as to the number. Buyer has not relied on any information or opinions of the broker or salesperson on this matter. This is important to understand because a lot of times when land is conveyed from a seller to buyer, there may be land divisions attached to property, especially with vacant property. Many purchase agreements may have an indication of how many land divisions are attached to the property and being sold with the property, where others we may not know. Again, this is just saying with unplatted lands or vacant lands that the seller represents the property is not a new land division. This is just a disclaimer to try to protect the seller. And it's also explaining that the buyer has not relied on any information or opinions of the broker or salespersons on how many land divisions that there are remaining. Paragraph 26, Legal Counsel. Buyer acknowledges that broker and or salespersons have recommended that buyer retain an attorney to pass upon the marketability of title to the property. The parties acknowledge that broker and or salespersons have recommended that they each retain an attorney to ascertain that the requirements of this agreement have been met. As a buyer's agent, we always recommend or always encourage that if a buyer wishes to seek legal counsel, that they have every right to do so. Paragraph 27, Due on Sale. Seller understands that selling or transferring the property does not relieve seller of any mortgage obligation or other indebtedness to which the property is subject, unless otherwise agreed to by the lender or required by law or regulation. This due on sale clause basically is to ensure that the seller is aware of their legal requirements and obligations to pay their mortgage, that they can't just not pay that mortgage off. Paragraph 28, Consent to Fees. The parties acknowledge that brokers may be offered placement fees, finder fees, and other considerations from others who become involved in the sale of the property. The parties hereby grant broker or brokers permission to receive such fees and or consideration, unless otherwise agreed in writing. Consent to fees is normally seen within a form known as Affiliated Business Disclosure Form. That is a topic that can be discussed at another time, but in essence, the Affiliated Business Disclosure Form allows us to state that if you use a certain business or company, that we may financially benefit from that relationship by choosing that company. Paragraph 29, Casualty. In the event that on or before the closing date, any building or other improvements on the property shall be damaged by fire, storm, or other casualty, and the cost to repair same is in excess of 10% of the sales price, either party shall have the right to rescind this agreement by written notice to the other party within 7 days after receiving notice of such casualty, and buyer shall be entitled to a refund of any earnest money. Typically, what we end up seeing is that if there's a fire in the home that actually damages more than 10% of the sales price, the buyer may have the right to terminate the agreement, or the buyer and seller may work on an agreement or with an addendum to ensure that the property is repaired and corrected to buyer's satisfaction to move forward. But the casualty clause just allows the buyer protection in case of a disaster within the home that affects more than 10% of the property based on the sales price that was agreed upon. Paragraph 30, arbitration. The parties acknowledge that they have been informed that any claim or dispute between them related to this agreement may be arbitrated if seller and buyer each agree in writing to such arbitration. Paragraph 31, earnest money resolution. If this agreement is not closed in the time and manner provided, the selling broker shall have the right, but is not obligated to propose a final disposition of the earnest money in writing to buyer or buyer's salesperson, and to seller or seller's salesperson, unless broker, within 30 days of the date of giving such notice, receives different instructions in a written instrument signed by both of the parties, or is furnished written evidence that a lawsuit has been filed relating to enforcement or termination of this agreement, or disposition of the earnest money, all parties shall be deemed to have agreed to broker's proposed disposition of the earnest money. If a party objects, and no mutually agreeable disposition can be negotiated, broker may deposit the funds by interpleader with a court of proper jurisdiction or await further actions by the parties. In the event of litigation involving the earnest money in whole or in part, the non-prevailing buyer or seller, as determined by the court, shall reimburse the other for reasonable actual attorney's fees and expenses incurred in connection with the litigation, and shall reimburse broker for any reasonable actual attorney fees and expenses incurred in connection with the interpleader action instituted. This is important to understand that as a buyer's agent, if your buyer is using star title, the money that's going to be held in escrow will be held with 5-Star Real Estate. Our brokerage, if there is a dispute in EMD and how that money is to be released, our broker actually can submit a written notice to the listing agent and listing broker, giving them notice that they have 30 days. And if they don't disagree with our notice, or if there aren't any legal action that have been filed for this EMD, that our broker will release any and all EMD funds back to the buyer. Paragraph 32. Counterpart/signatures. This agreement may be signed in one or more counterparts, each of which will be deemed to be an original copy of this agreement. The extent of the counterparts and signatures basically states that if you have two buy-sell agreements, if a buyer signs one copy of it and the seller signs another copy of it, that we can put them together and we can accept them as one purchase agreement, even though the signatures are on two different forms. Furthermore, the exchange of copies of this agreement and signature by facsimile or other similar electronic device shall constitute effective execution and delivery of this agreement as to the parties, and may be used in lieu of the original agreement for all purposes. Copies shall be deemed to mean any duplicate, reproduction, or similar or exact imitation of the original executed agreement. Signatures of the parties transmitted by facsimile or other similar device shall be deemed to be their original signatures for all purposes, and shall be deemed valid and binding upon the parties as if their original signatures, initials, and modifications were present. Neither buyer nor seller shall assert the statute of frauds of non-enforceability or validity of this agreement because of facsimile or similar electronic device copies being used, and both the parties specifically waive and relinquish any such defense. Each party agrees to provide an original signed document to the other upon request. Paragraph 33. Home Protection Plan. The parties have been informed that home protection plans are available. Such plans may provide additional protection and benefit to the parties. This is simply just stating that as a buyer's agent, you have let your client know of any and all possible home protection plans that may be available to them. Paragraph 34. Other provisions. This paragraph is actually blank and just has lines. Under the other provisions paragraph, we will normally see where buyers will write down any seller concessions that they may be asking for on behalf of the buyer. It may be as simple as seller to pay buyer's closing costs or prepaids, or seller to pay a 1-year home warranty on behalf of buyer. The paragraph 34 other provisions is where a lot of common clauses are indicated within a buy-sell agreement. Many of these common clauses are located within .loop already for your convenience, but we always encourage you that if you are unsure of certain language, that you reach out to the deal doctors. Paragraph 35, default. If buyer defaults, seller may enforce this agreement or may declare buyer's right to purchase terminated, retain the earnest money, and pursue seller's legal remedies. If seller defaults, buyer may enforce this agreement or may demand return of the earnest money and pursue buyer's legal remedies. Broker or brokers and salesperson or salespersons have no responsibility for the performance of this agreement by the parties. This is simply stating that brokers and salespersons cannot enforce a purchase agreement. If there is ever a dispute between a buyer and a seller, it will be imperative for either party to seek legal counsel to be able to enforce the outcome of any buy-sell agreement. Paragraph 36, earnest money. Buyer is depositing blank, either as cash, check, or a note with broker as earnest money, evidencing good faith. Broker is required by law to deposit the earnest money in a separate custodial trust account within 2 banking days after this agreement is signed by the parties. If the offer made is not accepted, or if the sale is not closed due to a failure to satisfy a contingency specified herein for a reason other than the fault of a buyer, the earnest money shall be refunded to buyer. The earnest money will be applied to the sale price at closing. It's important as a buyer's agent to ensure that you indicate what any type of good faith deposit or earnest money amount will be, and whether it's in cash, check. We don't typically recommend cash. We recommend a check, potentially a cashier's check of sorts. And then you want to ensure that that money is deposited with 5-star real estate as soon as you execute a purchase agreement. You should be having your client provide you with the earnest money deposit, and then you should immediately be surrendering those funds per the occupational code to the broker. Now, keep in mind, if you sign a purchase agreement at 10 o'clock at night, we don't expect you to drive to 5-star office that night, but we would request that by tomorrow morning when you're up and about, that earnest money deposit be dropped off at your local office for deposit. Paragraph acceptance states, when signed by both parties, buyer and seller agree that this shall be a binding agreement for the sale and purchase of the property. Delivery of acceptance of this offer after signing by the parties is not necessary to create a binding agreement, meaning that once both parties execute the buy-sell, it's a binding contract. Doesn't mean that you have to give the original back to the other party. Again, delivery of acceptance of this offer after signing by the parties is not necessary to create a binding agreement. So once the buyer signs, submits it to the seller, as soon as the seller signs, that's when the contract becomes binding. And then they will have to give you a copy of a fully executed contract. But once that seller signs, it becomes a binding agreement. Paragraph 37, time is of the essence. This is a legal term that's used quite often in most legal contracts, and time is of the essence with respect to this agreement. Time limits shall be strictly observed. What this means is that with any future covenant or timeline, that time is of the essence and that these timelines mean something, and that it's up to you to ensure that you follow all the timelines associated within the buy-sell agreement. Paragraph 38, authorization. Buyer gives broker until blank, and then the date and year, and then the time, to obtain seller's written acceptance of buyer's offer. This is important because this is the point where the buyer's agent will be filling out how much time you're going to give the seller to accept this buy-sell agreement. Paragraph 39, final agreement. This agreement expresses the entire understanding between the parties concerning this transaction and supersedes all previous understandings, whether oral, written, or electronic, including any promotional materials or listing descriptions. No modification of this agreement shall be binding unless in writing and signed by buyer and seller. In signing below, the parties acknowledge that they have read the agreement carefully before signing and have received copies of pages 1, 2, 3, 4, 5, and 6, as well as any attachments. Within this, you also, as a buyer's agent, you also want to make sure that any attachments, not only pages 1 through 6 of the buy-sell, but any attachments are also included, such as a seller's disclosure, lead-based paint disclosure, any type of addendum that you have created within that, or any exhibit. Paragraph 40, future notices. The parties authorize broker and brokers to use the contact information set forth below for notices after the last dated acceptance of this agreement. During the term of this agreement, the parties agree to notify broker or brokers of any contact information changes. The contact information set forth below shall not constitute a material part of this agreement, and any addition or modification of the same shall not constitute a rejection of an offer, the creation of a counteroffer, or an amendment to this agreement. Any future notices required or permitted to be given under this agreement shall be in writing and signed by the party giving notice. Notice shall be deemed to have been given when 1. At the time of personal delivery, or 2. At the time sent by facsimile with a successful facsimile confirmation sheet, or 3. At the time sent by electronic mail. Future notices shall be given to buyers or sellers' brokers and shall constitute notice given to buyer or seller, respectively. If either party is not represented by a broker, future notices shall be given to such party directly. At the bottom of the buy-sell agreement, there's also a place for the salesperson's name to be printed, for the salesperson's phone number, for the salesperson's email. There's also a place for the buyers to record their street address, their city, state, and zip. With regards to the buyer's signature to the right, there are 2 places for 2 buyers. There's also a place for them to print their legal name as you wish it to appear on final papers. If by some chance you have a 3rd or a 4th buyer and you're using dot loop, you can go ahead and try to add their signatures to the page, or you can get another page 6 of 6 to add to the purchase agreement and indicate it as an exhibit. Section 41, the above terms of sale are, after the buyer fills out a buy-sell agreement, this is where the seller will either accept the offer or counteroffer. There's only 2 places for the seller to indicate. One is accepted as offered, or the other is subject to counteroffer number. There's also a spot for a date and time for the seller to fill out so that you can verify that they have accepted this offer within the correct time frame that was provided to them under Section 38, Authorization, where it states the buyer gives broker until a certain date and time to obtain seller's written acceptance of the buyer's offer. Under paragraph 41, the salesperson's name, salesperson phone number and email, and the seller street address, city, state, and zip will also be placed, as well as the sellers to sign and print their legal names. This concludes the review and summary of the G-Car buy-sell agreement. If you have any questions or need further clarification, please contact the Deal Doctors at area code 616-490-0902. Thank you.